Good morning to all of you. Welcome to my ethics class. Friends, so far we have discussed up to 2022, but in 2019 there is a peculiar problem. Question number 15. The brief facts of the problem read like this. The State Bar Council, they passed a rule. What is that rule? The rule gives power to the to remove the chairman with no confidence motion. But the chairman says it's ultra virus. Please remember. So it can't be done when once a person is elected as the bar council chairman, he has to continue for the particular period. But nobody can remove him, whether this is correct or not. Very typical question. Normally, I have told you regarding the professional ethics, the rules of conduct, code of conduct, behavior, accountancy, duty to the opponent, all these things, but not whether the chairman can be removed or not. So the reply will be yes. You can't say no, because there are so many occasions. I will give you those incidents also. Please remember, here there is a very famous case also. Bar Council of Delhi versus Bar Council of India, 1974. Right? So please remember, regarding the elections, regarding the membership, regarding the quorum, regarding the resolution to be passed, all these things, they are covered under section 15 of the Advocates Act 1961. Even though there is no specific rule as to how to remove the chairman, because even constitution also, it has got a procedure. Suppose you want to go for impeachment against a high court judge, there are a lot of procedure. That procedure is prescribed, but here it's not prescribed. But still, please remember, as per section 15, yes, that too. Second point is, the association was registered under the Registered Cooperative Societies Registration Act. So this will be controlled by the so-called act also. So please remember, if at all the majority they want to pass no confidence motion, yes, they can succeed. This is what happened in the particular case of Bar Council of Delhi versus Bar Council of India, 1974. Right? The majority of the Bar Council of India, they expressed a view that there was no provision on the whether there no provision in the act or also rules for the removal of the chairman by the so-called no confidence motion under section 15. No rule for such as removal can be made. So this is the Bar Council of India opinion. So how this thing has emanated? Let us know the brief facts. In 1969, Bar Council of Delhi, they elected Radhe Mohan or Radha Mohan. Radhe Mohan as its chair, Radhe Mohan Lal as its chairman. But due to differences on 22/9/1972, after 3 years, so the resolution of no confidence motion was passed against him by the majority. So, but the chairman disputed its legality and he approached the BCI requesting for directions in this connection. So BCI said, even under section 15, no specific rule is there how to remove the chairman with no confidence motion. But please remember, rule 33, as per section 15, rule not our professional rules, rule 33 says chairman can be removed by no confidence motion. Supreme Court held that section 15 empowers the Bar Council to make a rule for summoning the members of the meeting to go for the so-called no confidence motion. This is a case law. Please remember this case law. An incident I want to tell you, of course there is no case law. In 2012, so the Bar Council chairman of Karnataka State Bar Association, his name is Ananda Kumar Appu Magdum. Ananda Kumar Appu Magdum. Actually, he was also removed from the chairmanship. Actually, on 31/3/2012, on 31/3/2012, the Chief Justice of India visited Bangalore, and at that time, the Bar Council President, he has to present a memorandum to the Chief Justice of India, and he has to give the welcome address also. So So ultimately, the members felt that the chairman did not know even to pronounce a single word of English correctly. Number one. Number two, the poor command over English. So they thought that it is better to remove him. Ultimately, on 31/3/2012, so because of this incident, immediately they called for a resolution. Out of 25 members, 14 supported in favor of the resolution. What is the resolution? No conference motion against the Bar Council of Karnataka chairman Mr. Ananda Kumar. Ultimately, yes, he lost the post. He was unseated, literally. Because there are so many allegations, not only this not speaking fluently before the CGI, at the same time, whenever there was a boycott by the lawyers, he did not take initiative, he did not conduct any meeting. So many other things are there. But anyway, this is the reason with which he has been removed or unseated from the chairmanship. So I think by now you are clear or you are satisfied that the Bar Council chairman can be removed by no confidence motion. So if at all such a problem comes, please write that case law as well as mention this incident also. But in this connection, please remember, BCA later made some rules. Rule number 1, the Bar Council chairman, no confidence motion should be put in the cases of number 1, proved misconduct by the chairman. Second, when he is convicted in any incident of moral turpitude, and if he is guilty of professional, guilty of disciplinary proceedings. So 30 days notice has to be given. So no conference motion, it should be actually approved by more than I think 50%, and ultimately if the no conference motion fails once, secondly it cannot be brought for the next 12 months. That means after 1 year only they have to go for another no confidence motion. These are the guidelines given. Anyway, good case. Please remember this case law if at all it comes, because I have not spoken in detail in the class. Better you see the video once or twice and enrich with the legal knowledge. With this I am concluding. Thank you very much.